She comes from the academy, having been a law prof at, was it Catholic University, and is co-author of International IP Casebook. So with that, I will give the floor to Sai, and we'll have, each of them will talk for a little while, and then I will open it up. I'll ask a couple questions and it'll open up to you.
Great, thank you, Brad. First of all, I'd like to thank the Kernochan Center for hosting this really terrific event. I'm sure Shira would agree, it's really great to get out of Washington and come to New York, and to hear how we in government can help make the copyright laws work for you, for the authors, for the performers, and really for the public at large. So what I'm going to do today is briefly discuss 5 of our recent and ongoing policy studies, but before I do that, I wanted to step back and make one overarching point. In March of last year, the Register of Copyrights was here at Columbia to deliver the Manges Lecture, in which she called for the next great Copyright Act. And in it, she provided what I think is a key insight that was alluded to before. She said, quote, "The issues of authors are intertwined with the interests of the public. As the first beneficiaries of the copyright law, authors are not a counterweight to the public interest, but are instead at the very center of the equation." And I really like that passage, and I am not just saying that because she's my boss. The reason I like it, the reason I think it's a valuable insight, is that it's an antidote to the typical rhetoric that seems to pit authors against the public, or that mistakenly suggests that copyright is a zero-sum game. It's not a zero-sum game. I think we in government believe sincerely that there's ample room for smart reforms that will ultimately benefit everyone in this room and everyone outside of it. And so I think that's the fundamental attitude that the office has brought into its recent policy studies, finding solutions to problems in the law or in the marketplace that will benefit all creators in a way that ultimately benefits the public at large. So last year, the office issued 2 reports that I think exemplify that spirit. First, we issued a report in September proposing the creation of a small claims tribunal. It's a proposal that's been mentioned several times today for copyright owners who are seeking relatively minor damages. As has been discussed, the barriers to pursuing infringement claims in federal court are formidable. As Professor Zabotnik mentioned, the median cost for litigating an infringement claim through appeal, as we found, was $350,000. That's not workable for many creators, if not most creators, and particularly in situations where the impact of any individual infringement is likely to be low, but the overall aggregate impact of infringement is akin to death by 1,000 cuts. I think the phrase was used earlier today. And so what we've proposed in our report is the creation of a centralized tribunal within the Copyright Office to handle small infringement cases valued at no more than $30,000. It would be a voluntary alternative to federal court, akin to arbitration. Adjudication would be low cost. It would be streamlined through the use of online and teleconferencing facilities, and decisions would be binding on the parties and enforceable in federal court. And so what we've seen since the report issued is that there seems to be a fair amount of support on Capitol Hill for some sort of small claims process. This past July, I think, the House Committee, Subcommittee on IP held a hearing on copyright remedies, and there was widespread support for some sort of small claims process among the witnesses and the members of Congress. So I think we're hopeful that sometime soon we will start to see some sort of legislative proposal to implement a small claims solution. The other report we issued last year addresses an issue that I don't think has come up yet today. Involves the resale royalty right, and we recommended that Congress consider adopting a resale royalty right. And so this is meant to address a different sort of market failure, one that's particular to visual artists like painters, sculptors, illustrators, and photographers who produce a relatively small number of unique works that often increase greatly in value in the resale market. And because of that fact, under current law, I think those creators are uniquely unable to share in the full fruits of their labor. And so what our report noted is that since 1992, when we last looked at the issue, the number of countries recognizing a resale royalty right has more than doubled to over 70, including the entire European Union. And I know Canada and China are looking at this issue as well. And again, since our report's issued, we've been gratified by the progress that's been made on Capitol Hill to implement this proposal. And in February of this year, legislation was introduced in both the House and the Senate. It's called the ART Act to implement a resale royalty right for visual artists. It was sponsored by Representative Nadler in the House and Senators Baldwin and Markey. So we've seen some legislative movement on that front. So I'll just touch briefly on the 3 pending studies we're working on. And I can't say too much about it because we're still thinking through the issues, but I'll say what I can. The first study, which we hope to issue by the end of this year, is on orphan works and mass digitization. It's another issue that's been discussed today. And it's really addressing 2 distinct, though interrelated issues. One is about individual uses of orphan works, and the other is about mass digitization of lots of works, which can include orphan works. And Congress, as a reminder, Congress considered orphan works legislation in 2006 and again in 2008. And in fact, in 2008, the Senate passed orphan works legislation, but it just never passed the House. So in terms of our findings, in terms of what we've seen in the most recent study, I think it seems fairly clear to us, at least, that, that current law is hindering what might be productive and beneficial uses of copyrighted works merely because the current copyright owner can't be identified and located. And what Registrar Palante has said is that this is a situation that benefits no one. It's better that we have some sort of licensing mechanism in place to allow these productive uses to occur. And that's the same is true in mass digitization. That's an issue, obviously, in the Google Books litigation. The district court found that what Google Books had done was a fair use. But regardless of how that litigation comes out, I think it's fair to say that there's going to be a scope of uses of mass digitization that are going to not be fair uses that are nonetheless would be beneficial for society. And I think it behooves us to think about solutions to allow licensing and allow those sorts of uses to occur. So this problem, I don't think, is solved necessarily by even assuming this district court decision in Google Books is affirmed. That doesn't solve the entire problem. So so I think we still think that there's some sort of broader solution that's going to be needed. So the second pending study is the manner in which the U.S. law implements the rights of making available and communication to the public that are guaranteed by the WIPO Internet treaties. Obviously, we believe that U.S. law, when properly interpreted, unambiguously protects those rights through a combination of our exclusive rights. But particularly with the advent of digital distribution models, there are some courts and commentators that have expressed uncertainty about how U.S. law maps onto our international obligations. And so Congress asked the office to examine that question, both in the U.S. and overseas, and to assess whether clarification of U.S. law might be necessary. And this study is interesting. It raises lots of really interesting and sort of broad issues involving copyright in the digital age. For instance, does merely placing a copyrighted work in a publicly shared file folder violate the owner's exclusive right of distribution? Or do you need evidence that another user has actually downloaded it? Even more broadly, what are the dividing lines between the rights of distribution, performance, and reproduction in the digital world? Do those categories of rights even make sense anymore in the digital world? And to go back to my overarching theme, the goal of this study, the issue here is not about maximizing authors' rights to the greatest possible degree. It's really about ensuring that modern copyright law reflects the realities of the modern digital age. And that copyright law facilitates rather than hinders the development of technologies that fulfill consumer demands for copyrighted works. And again, uncertainty in this area benefits no one. It doesn't benefit the public, and it doesn't benefit creators. So finally, there's the music licensing study. As many of you here know, I've been fairly heavily involved in that. Music licensing, as I think has been mentioned earlier today, is one of the more bewildering areas of copyright law out there. It involves distinct works, distinct rights, a combination of statutory and private licensing, these antitrust consent decrees. So what we're trying to do in the office is look at this entire market with fresh eyes and help highlight for Congress what the central problems are. And I'll just highlight 2 of the issues. There are a lot I could talk about, but I want to make sure we leave enough time for questions. But the 2 issues I wanted to highlight that we're really thinking about are fair rate setting for government, in the government-regulated licenses. There are all of these distinctions that have, in rate setting standards and methodologies, that have crept into the system more by historical accident than by any sort of intelligent design. And not all of them make much sense anymore in this digital age. And so I think that's one area that we're going to think about very seriously. The other issue is data standards and licensing efficiency. I think several of the earlier panelists mentioned data issues. I think there's common agreement that identifying what works are being used and figuring out who owns those works is a major problem in the music licensing system in particular. It's obviously a problem in many of the copyright systems, but music licensing in particular. So that's an area that I know that we're thinking a lot about, and it's an area that's going to get a lot of our attention, I think, in our eventual report. So there's a lot more I could talk about in that in music licensing, but I think I'll stop there and turn it over to Shira.
Is this on? So I also would like to thank Columbia Law School and the Center for Law and the Arts. I'm very pleased to be here at another one of the exceptional programs that they put on in this location. And in particular, in getting to speak on a program with so many very impressive creators, authors, and performers. And I do just want to start by saying the creativity of so many of you in the room and those you represent produces the works that really shape and color our views of the world. And I think it's critical that we have a copyright system that appropriately protects and respects and remunerates those contributions. So I think the interests of authors and performers on many issues and in many respects coincide with those of copyright owners generally, but obviously not always and not entirely. And it's important that policymakers are aware of the areas where the interests coincide and also where they diverge and require attention. So that's something that we very much keep in mind, I think all of us in Washington, as we look at these issues. So I thought I would just start, because often I get a question, you work for the Patent and Trademark Office, why are you speaking about copyright? So I thought I would explain that a little bit for those who aren't aware. The director of the Patent and Trademark Office by statute advises the president, in fact is the principal advisor in the administration for the president on all IP policy issues. So we have a strange setup in our government where we are the principal advisor in the administration on IP policy, and the Copyright Office is in the legislative branch, but we work very closely together and try to coordinate to the full extent possible, and I think we've been doing a very good job of it. So there's also the fact that on international IP negotiations, the Patent and Trademark Office, as part of the administration, leads the delegation. And then add to that the fact that the Patent and Trademark Office, as part of the Department of Commerce, and the department as a whole is very interested and involved in issues relating to the digital economy. Secretary of Commerce sees that as one of her priorities, Secretary Pritzker as well. So that's the background of why we're here participating in the conference, even apart from my own personal background. So what I will do is talk about the green paper that we issued last year on copyright creativity and innovation in the digital economy, and then the work that we've been doing since then, and in particular how it relates to individual authors and performers. Talk a little bit about some international developments, and then just close with some ideas on how all of you can play an effective role in the policy debates in Washington. So the green paper we published in July 2013. It was a Department of Commerce Internet Policy Task Force product, and the PTO took the lead in drafting it. And since then, we've been following up in work on it. Now, one of the things I thought would be helpful to make clear is the relationship between what we covered in the green paper and the work that's going on both in the Copyright Office and in the congressional review. So there is some overlap, but we're trying to make it not duplicative overlap. And also the scope of the exercises are a bit different. So the green paper is narrower in the sense that it is only deals with copyright issues related to the internet, whereas both the Copyright Office and Congress are looking at everything in the Copyright Act. For example, resale royalties, which almost by definition doesn't relate to the internet. It's broader in the sense that it's not looking so specifically at the statute and at legislation, and we're also very interested in questions about the marketplace and practical issues of how copyright is working. So there's similarities and differences, and we did, on many issues where we knew that the Copyright Office and Congress had a particular interest, express support, express a position that these were positive areas to go into and the administration would be supportive and try to contribute. But then we tried to find other things that we could do that would not be overly duplicative. I know some in the room who've been very busy preparing comments in response to all of various requests coming from all of us may feel a bit overwhelmed, but we're trying to make it work for you. So we divided the green paper into 3 separate areas. One had to do with preserving the balance of rights and exceptions as the law is updated, so it's sort of the policy issues. Second deals with enforcement. How do you make sure that those balanced rights continue to be meaningful in the internet environment? And the third dealt with the online marketplace. So I won't list all of the recommendations because it's a long document. It's 99 pages, very carefully kept just below 100 by clever juggling with type size and number of footnotes. Margins, yeah. You're all familiar with doing that. It's so much easier now with digital technology. But what I will do is talk about the areas that we outlined, that we identified as places where we in the Department of Commerce would take work forward ourselves, and then let me tell you what we're doing in those areas. So in the area of the policy issues, rights and exceptions, first of all, we essentially hailed some of the issues the Copyright Office was attending to as being extremely important and saying that we supported work going forward, and that includes some of the exceptions issues like orphan works and mass digitization. It includes some of the music licensing issues. So we're very supportive of that and are following it with great interest. On areas that we would take work forward, where we have been taking work forward, there are really 3 policy issues. One has to do with remixes or mashups. And we commented that we posed the question of whether the existing combination of laws and licensing mechanisms were sufficient to allow creative new content that relies on those techniques to be able to be produced and disseminated, or whether anything needed to change. Second, we looked at the application of the first sale doctrine to digital transmissions. And on that issue, we asked, has anything happened since 2001 when the Copyright Office issued a study recommending that the doctrine not be extended to apply to digital transmissions? Has anything happened since then that would lead to other conclusions? And in particular, we tried to move the discussion away from a black and white yes or no, the doctrine should or should not apply, to a more nuanced examination of what are the benefits that the doctrine produces in the analog world, and do we need to do anything to make sure that we have similar benefits in the digital world? And then the third issue was statutory damages, and in particular, not whether they should exist or not. We underlined the importance of statutory damages as a deterrent and as a way for copyright owners to get compensated where it's difficult to prove actual damages. But we said there are some two very specific circumstances where people have raised questions repeatedly about how statutory damages are calculated. And one of them has to do with individuals who are file sharing, 2 very famous cases involving high levels of jury damages, as many of you know. And the other situation is online services making available entire repertoires of works where they could be held secondarily liable and a normal statutory damages calculation based on the number of works could lead to billions or trillions of dollars in statutory damages. So we said, do we need to look at how statutory damages are calculated in those two specific circumstances? So what we've done since the Green Paper came out now over a year ago is to have a series of, in addition to public comments, written comments, we've had a series of roundtables around the country in 4 centers of copyright activity, Nashville, Cambridge, Massachusetts, Los Angeles, and Berkeley. And we're now working on our conclusions, and we'll be issuing a paper summarizing what we heard, what we think about what we heard, hopefully early next year, early in 2015. Second, on the enforcement side, I did want to make the point, because a number of people have raised this today, that one of our conclusions in the Green Paper on the enforcement side was that public education and awareness has got to be a key component, that we need to make sure that the public understands why we have copyright, what it's about, how it affects them, and why we're doing anything we're doing. If we're going to change the law, if we're going to take some new enforcement initiative, we need to make sure that people see why we're doing it and what it's about and what it means. Because especially since the demise of SOPA and the Protect IP Act, it's just very critical that we develop legitimacy for what we're trying to do and not just assume that things will be accepted. We need to make sure that there's not a lot of misinformation out there so that we can have rational discussions. Second, on small claims, we supported, again, the work that Copyright Office was doing, and since the Green Paper came out, of course, we now have the very thorough and well-reasoned Copyright Office recommendations, and we don't have an official administration position on the exact recommendations at this point. I hope we'll be able to develop one and continue to be helpful. And then on one other area of enforcement, as also was alluded to earlier today, the administration, in particular the IP Enforcement Coordinator's Office, has done a lot of work on promoting voluntary best practices, cross-industry voluntary best practices, and we supported that as well. And the Patent Office is currently in the process of doing a study of what the impact of the existing voluntary best practices are. Because obviously we can say they're a good thing, but unless and until we can see that they are having some positive impact, it's hard to say that that alone is enough. So we want to look at that, and that we were asked to do by the IP Enforcement Coordinator, and that's in process as well. And then we identified one other project in the Green Paper that we said we would take forward, and we've been working on that all year. And that is establishing a multi-stakeholder forum to look at how we can improve the operation of the DMCA notice and takedown system. So there was a lot of discussion of the notice and takedown system today and some criticism. And I think we've heard a lot of comments and concerns about it. As we looked at the comments we received in response to the Green Paper, it became clear that while some of the suggestions would involve reopening the legislation and amending the DMCA, there was also considerable concern about the unanticipated consequences and the risks of doing that. And it also seemed as if a lot of the concerns that were raised were things that might be dealt with without legislation. If we could put people together in a room and say, can you work out some best practices, some ways to improve the situation on all sides? Because it really was a situation where everyone had their own concerns that needed to be addressed. So in particular, some of the concerns were about the volume of notices. Some of the concerns were, as you heard today, about content that was taken down being immediately reposted. Some of the concerns were about abuse or misuse of notices. And some of the concerns were about the ability of individuals and small entities to use the system effectively. So all of that is on the table. We put together this multi-stakeholder forum. We have broad representation, including from a number of individual creators. And that group has been meeting about every 6 weeks. They've established a smaller working group to have more technical conversations and do drafting. And we did start in one of our initial meetings with a focus on the challenges for individuals and small businesses in using the notice and takedown system. So that's been moving along. I know a number of the participants are here in the room. Sandra Astars from the Copyright Alliance is one of the co-chairs that's been helping to make progress. And our goal and our hope is that by the end of the year, we will be able to produce at least some output, which would be probably in the form of some best practices. I won't go into a detail. This is all, information about all of this is public and available on our website. And then on the third basket, on the online marketplace, essentially we looked at all the things that are happening in the marketplace and did make the observation that over the last 5 years, the legitimate online marketplace in the United States has really taken off, that there's a very large variety of works available in many different formats. And then we talked about those areas where there was still room for improvement. And ultimately, we focused on the fact that we really need good data out there of who owns what rights. We've had a lot of discussion about that today. We talked about the importance of the Copyright Office public databases and supporting the Copyright Office and being able to have the resources they need to do all of the re-engineering and improvements that the Register is looking to do. We talked about the value of being able to link those public databases to private databases that collecting societies and unions and other organizations may have available, and that's also something I know the Copyright Office is interested in. And of course, that's good for everyone, whether it's authors and performers or larger entities. We talked about the need to have more connections across creative sectors and more interoperability and standard identifiers, and again, I think that's something that benefits everyone. And we also talked about the possibility of establishing in the United States something like they're doing in the UK, which is a copyright hub, which could be a platform to connect to different licensing mechanisms in different sectors. We're trying to get more information about where that stands in the UK, and I think in particular that's something that should be of great interest for small transactions by individuals and not just big commercially sophisticated entities. So on that work stream, we are going to be having upcoming consultations. We haven't announced it yet, but we're going to be issuing a request for comments sometime in the coming months and probably planning some kind of workshop or roundtable late this year or early next year. So that's where we are, and I just, to mention one international thing, of course, we negotiated in the summer of 2012 a new treaty to protect performers and audiovisual works. And we are working hard with the Copyright Office and the State Department to prepare materials so that we can start moving toward ratification and implementation of that treaty. So that's something of great interest, I know, to many of you here. So I just wanted to close by saying a few words about sort of the Washington scene and the role of authors and performers. Just to say, I think you can all make a real difference in the policy debates in Washington. And while there is a cacophony of voices there these days, and some of them are very big and sophisticated and well-funded, you do have certain natural advantages as individual creators. One is just that you are very appealing as an interest to protect. It's hard for anyone to come out against creating individual creators, protecting individual creators, and I think we saw that with the Beijing Treaty, where every country wanted to protect their creators, and none of the usual players who sometimes oppose new and stronger rights were not supportive of that treaty moving forward. I think you have the ability to balance some consumer perspectives in the sense that you can make the point that there are individuals on all sides of the issues as both users and creators. And I think policymakers really do want to hear from you and to help you. And in fact, as many of you will have seen, you're often the stars at congressional hearings and at WIPO conferences. And for those of you who saw Stevie Wonder at the WIPO General Assemblies and then again at the Diplomatic Conference in the Marrakesh Treaty, you saw what an influence he had there. And I do think, you can be heard through your associations, whether there's specialized associations like the Songwriters Associations, the Association, the Screen Actors Guild, the other guilds and unions, or the broader groups like the Copyright Alliance. But you can also be heard as an individual, and I know you're all very busy creating and working harder than ever before because it's harder to make money out there. But just to say, there are more options, and it's easier than ever for individuals to contribute to the debate. So please respond to our requests for comments. We read very carefully those that come from individuals as well as associations and businesses. Please come to our roundtables and our workshops and our conferences. You can sign up for Copyright Office alerts. You can sign up for the PTO on our website. We have a copyright page, and you can sign up for alerts about our copyright activities as well. And finally, in terms of what messages have the greatest impact, I think it's very helpful and very positive to hear individual creators supporting the industries that are copyright owners where your interests do converge, that adds tremendous weight to the messages that they're sending, if you can add your voice to that. I think it's good for you to be clear about those areas where you also do have separate needs. But if, to the extent that you can avoid getting bogged down in the internal fights, that would be helpful, because sometimes it can dilute the message if there's a lot of discussion about problems between producers and creators, unless, of course, there's some particular policy change you want, then obviously you need to raise it. I think it's great if you can provide actual evidence, because there's an increasing emphasis on evidence-based policy making everywhere, Washington and elsewhere. But your emotion is important too, and having people be able to see how passionate you are about your work and your creativity, I think makes a big difference. And then finally, to the extent that you can propose actual solutions and solutions that are realistic to your problems, that's great, because we all need to find answers, and often you'll be able to come up with better ones than those of us sitting in Washington can. So, this may all sound obvious, but I was just thinking about what I thought has worked in my experience from a Washington lobbying perspective. So thank you for indulging me in communicating those ideas.
So a couple of things. First, I just wanted to note that towards the back of your program is a materials section. These aren't included in the program, but they are all on our website. So things we talked about earlier today, like the Garcia v. Google case, what Shira just referred to in the Beijing Treaty, what Cy referred to with 2 of the Copyright Office notices of inquiry, they're all on our website. The green paper actually is not, which it should have been, but you can very easily find it by typing in PTO green paper on Google. All these things are worth taking a look at, and they'll give more context to what we've been talking about today. We are running a little behind, so I'm just going to ask one question to the 2 of you and then open it up to the floor. And we've talked a lot today about fair use, but we haven't really talked about the role fair use plays for authors, what it actually does for authors. And when we talk about a small claims court, one of the things that I think about is, and this is something that's been discussed by academics at various times, but is whether or not we need an alternative adjudication process for a fair use defense. Jane was referring to what I, in a paper on copyright trolls, call presumptively fair uses, where the plaintiff is using copyright really more as a cudgel than as a means for reaping a reward on a work that was created for creation's purpose. And what I wonder here is when we're dealing, so we can sort of avoid those costs for creators who need fair use, so they can't just be sort of, wiped out by authors who want to misuse not authors, I'm sorry, copyright owners who are misusing their copyright. Is there a way we can do that without them having to go through the very expensive process of defending in federal court? Is this been in any way, shape, or form a part of the discussion with a small claims court, or with, or do you even see an institutional role here for either of your agencies?
So I will say, in the context of the small claims proposal specifically, we addressed the fact that all defenses could be adjudicated before that small claims tribunal, including fair use. So, to the extent that it would be something that falls within that proposal, that fair use would be an issue that would arise. And I know that there have been various proposals, not just in fair use, but generally, to give the Copyright Office more adjudicatory authority. obviously raises all sorts of constitutional issues in terms of our sort of status in the constitutional sphere. But, I think those are worth examining. I don't know that we have a position on things like, the fair use board. I think that Professor Carroll has that idea of a fair use board. I don't know that we have any particular position on that. I think they're interesting. I see why people think that would be a valuable thing to do. I think, opinion letters, the idea of fair use opinion letters has been discussed before. I think all of these are worthy of examination. I think it would require sort of a rethinking of the role of the Copyright Office, the administrative role of the Copyright Office as an agency. So I'll leave it at that.
I'd only add that I think it's worth being creative and thinking of ways to address the issue. And the small claims idea is an interesting one, and I think we should explore all options.
Okay.
Yeah, Shira, thanks for the closing remarks, because I think that they were very reassuring to the creative community. In the spring of 2013, at a House Judiciary Committee hearing, we were kind of treated to the surprising testimony of Professor Pam Samuelson presenting her principles, during which she mentioned that they had been developed with the input of the entire panoply of players in this sphere, except for creators. And when questioned about that, I think she mentioned something about law professors being creators, so that they counted. Has there, since that time, been a sensitivity raised on Capitol Hill and in the administration and the Copyright Office in terms of needing to deal directly one-on-one with creators to get their input and reaching out to the creative community rather than simply posting a request for comments?
Not as easy as it looks. I think we certainly are sensitive to the need to get input from individual creators. The difficulty is, how do you reach out? We are trying to get the word out as much as possible on all of the activities we're doing to invite comment and get people involved. And some of it we do through groups that are in Washington following all of this and ask them to talk to their members. I know when we put together the Multi-Stakeholder Forum on the operation of the notice and takedown system, we did do a lot of calling around and saying, how do we make sure we have a really good representation from all types of creators, as well as all types of users and technology companies, because otherwise we didn't think it was going to be a very representative and fruitful outcome.
I would agree. I think that's I think we care a lot about what what individual creators think. I think, as you saw when you were at our music licensing study, you were on the panel. We saw a lot of people representing the interests of individual creators. We had individual creators themselves at some of our panels, and I think that was very helpful for us. And I think it brings a useful perspective, because the copyright community is not monolithic. There are lots of sub-interests involved, and it's good to keep in mind all of those. And so I think we're very cognizant of that. I think we've been quite successful in the comments we saw in the music licensing study, at least, which I've been involved in. We got a nice mix of individual creators, the big companies, and everything in between. So yeah, so I think we obviously care about it. We do what we can in terms of outreach. We have our Newsnet, we have our website. We try to sort of drum up these sorts of insights from as wide a range of individuals and groups as we can.
Yeah, Melvin.
So I'll say that, I think that's an extremely fair concern, and it's something I know that the Register of Copyrights, Maria Palante, has talked a lot about, this idea of transparency and ensuring that that creators have transparency into the way that money is flowing into them. We issued new statement of account rules for the Section 115 license that we hope will enhance the amount of transparency in that licensing scheme. But I think it's something that needs to be attention needs to be given to that concern. I absolutely agree.
Yeah.
Hi, thanks for saying. It's very refreshing to hear you say that copyright's not monolithic, and also you're taking an evidence-based approach. That's really cool to hear. I just have a real simple question. It's about the Copyright Office website. I know the Patent Office has been trying to spruce up its digital capacities a little bit, and people are looking at PACER, the federal courts system. I'm just wondering maybe if Copyright Office is going to get its own digital house in order. Someone earlier mentioned, I think, just sort of shaping up the website. Is that going to happen?
We would love for it to happen. I was in the tech industry before I went to law school, and so yeah, I think I think everyone in the Copyright Office acknowledges that there is work to be done, and the problem is that our budget, I'm sad to say, is quite small. I came from a couple of other government agencies. When I found out that the Copyright Office budget was $45 million. It was surprising, and I tell my friends elsewhere in the government that fact, and they're quite taken aback. And so to run a 21st century digital infrastructure on that kind of budget is quite difficult. And so, yes, I agree. I think the Register is on record as agreeing with this point that yes, we need to bring our digital systems into the 21st century, and I think it's not for lack of will. I think it's really for lack of resources at this point.
Anybody else? I think we have time for one more question.
Thank you, Brad. I just wanted to say that, I was talking to somebody in the break about this, that we seem to live in a society and in a world where the individual has been devalued. And I think the creator is really kind of, I wouldn't say the canary in the coal mine, but I think is symbolic of a huge increase in corporate power in the last, in recent years, and a real diminution of the power of the individual. So as people who have some power in this area, I think whatever you can do legislatively or through regulatory means to re-empower the individual. And transparency, of course, is very important. I think recapture is a very important tool because it allows individual creators to come back to the corporate, I was going to say overlords, but I won't. It really empowering the individual, not just in the creative field, but across the board, I think is a real issue for our society right now. And I think, so whatever you guys could do to help re-empower the individual, to rebalance the landscape, the playing field, I think whatever you can do would be very, very helpful at this point. Thank you.
So I want to ask